Unemployment benefits. How to get what is coming to you. English text by Acadiana Legal Service Corporation. Audio PowerPoint by Southeast Louisiana Legal Services. Lost your job? The first thing you should do is file a claim at the unemployment office. Even if you were fired for good cause, you still should file to preserve your rights to unemployment benefits on future claims. Normally, you should be able to receive your unemployment benefits unless one of the following is true. You are not able to work or available for work. You were fired for misconduct connected with the work. You are unemployed due to your participation in a labor management dispute. You have failed to apply for or accept available, suitable work. You voluntarily quit, and it wasn't because your employer significantly changed your working conditions. You didn't work long enough to be covered. Your job wasn't covered by unemployment insurance. Turn down. If you've applied for unemployment benefits but have been turned down, you should know about your right to appeal. When you appeal, a different person looks at your case. If you win the appeal, you get your benefits. How do I appeal? There are 3 steps to appeal. Step 1. When you appeal a decision made by the Louisiana Workforce Commission, the Unemployment Office, an administrative law judge will hear your case. You must appeal within 15 days from the date you were mailed the decision turning you down. You have the right to have a lawyer or other advocate with you at the hearing. You also have the right to have the administrative law judge subpoena witnesses to testify for you, whether you have a lawyer or not. What happens at the hearing with the administrative law judge? Helpful hints to get you ready. You have a right to look at your file and to see what your boss has said about you. You have a right to ask the administrative law judge to subpoena witnesses and documents that you may want to use at the hearing. Before the hearing, you should have a strategy mapped out. You will only be given a few minutes to show that you were not fired for misconduct or that you quit because your employer changed your working conditions. At the hearing, you can object if your boss tries to tell things that he or she did not see or hear himself or herself. The judge's decision cannot rely only on statements about what other people may have seen or heard. The administrative law judge will record the hearing on tape. You must present all your evidence and say whatever is in your favor at this hearing. If the side that loses at this hearing appeals to the Board of Review or to a court, there will not be a new hearing there. At either of these appeals, they will only look at the papers used at the hearing before the administrative law judge and listen to the tape of that hearing. Step 2. If this administrative law judge rules against you, you have the right to appeal. You must appeal within 15 days of the date the administrative law judge mailed the notice turning you down. The Board of Review will look over the record of your case and listen to the tape of your hearing before the administrative law judge. The Board of Review may grant a new hearing if you have new witnesses or new evidence which you could not have presented at the hearing with the administrative law judge. Step 3. If the Board of Review rules against you, you may file a suit in district court. You must file within 15 days of the date the Board of Review mailed the notice turning you down. There is no rule that you have a lawyer to make this appeal and to represent you in court, but you will be at a big disadvantage if you do not have a lawyer. Warning: don't let any of your 15-day deadlines go by. Once these deadlines have passed, you may not be able to make your appeal, no matter how good your case is. Once I'm on benefits, how can I be cut off? Important. If you start getting unemployment benefits, you can be cut off if you don't continue looking for work by contacting at least one employer each week. You don't go to a job interview the unemployment office sets up for you. You turn down a job offer without a good reason. You don't go to the unemployment office when requested to go. If you do get cut off unemployment, you can appeal the same way you could if you had been turned down when you first applied. For more information or help, call the office of the Free Legal Services Program that serves the parish where you live. Many thanks to the Technology Initiative Grant Program of the Legal Services Corporation for its general support. Thank you for watching. This is a presentation by Southeast Louisiana Legal Services, a non-profit provider of free legal help to low-income people across 22 Louisiana parishes. Find more resources on www.louisianalawhelp.org.